During the course of our investigation of targeting of witnesses during the course of the conspiracy itself. There were election workers who had their lives turned upside down and received vile death threats because they were targeted by Donald Trump and his co-conspirators. I had a duty to protect witnesses in this investigation. That risk, that threat to witnesses was only confirmed when we went forward in this case and Donald Trump suggested that one witness should be put to death, and then also issued a statement to the effect of, if you come after me, I'm coming after you. In my mind, I can't think of a more direct threat to witnesses and individuals involved in that proceeding. Given that sort of threats, it was, in my view, completely appropriate to protect.
This may look like a prosecutor explaining routine legal decisions, but it's actually a test of how far state power can stretch in the name of protection. What's really being tested here is whether fear of interference can justify extraordinary secrecy inside a democratic system. This raises broader questions about how investigations balance independence, transparency, and restraint when politics collide with law enforcement. In this video, we'll break down how claims of witness protection intersect with constitutional limits and why that line matters far beyond this case.
The gentleman from Tennessee is recognized for 5 minutes.
Thank you, Mr. Chair. Mr. Smith, it's great that you've been allowed to come here and testify to the American public. Is there anything you'd like briefly to discuss that Mr. Gill brought up on the reasons why you needed those phone records and the limitations that you thought might have been on you and the prosecution because of to risk the investigation?
Sure, and I would begin by pointing out that the email that was referenced wasn't a justification from my office. It was an email from the Public Integrity Section to my office approving the subpoenas. The subpoenas that we secured with non-disclosure orders from a judge because I had grave concerns about obstruction of justice in this investigation, specifically with regards to Donald Trump. Not only did we have the obstruction of justice that we were investigating in the classified documents case, but I was aware during the course of our investigation of targeting of witnesses during the course of the conspiracy itself. There were election workers who had their lives turned upside down and received vile death threats because they were targeted by Donald Trump and his co-conspirators. I had a duty to protect witnesses in this investigation. That risk, that threat to witnesses was only confirmed when we went forward in this case and Donald Trump suggested that one witness should be put to death, and then also issued a statement to the effect of, if you come after me, I'm coming after you. In my mind, I can't think of a more direct threat to witnesses and individuals involved in that proceeding. Given that sort of threats, it was, in my view, completely appropriate to protect the integrity of the investigation, to protect against destruction of evidence, and to protect the witnesses in our case.
And just to make clear, you did not see any of the discussion. There was not any, it was just the content that they made a call to the president and vice versa, but nothing about any content whatsoever.
That's correct. A toll record subpoena gives you who a call is from, who it is to, and the length of that call. It does not tell you the content of what people are speaking about.
You felt that you had a case that was one that you would win beyond a reasonable doubt, no moral certainty. Is there anything in your facts that you had that you would have used at trial that you believe has not been presented to the public in the past or have been misrepresented to the public?
Is there anything?
Essential facts that you had that you felt would have resulted in a conviction of the president on the charges that he was indicted upon?
I think my report, the report of our case, the final report, summarizes the evidence, I think, in a way that is, gives a fair reading of the strength of the case.
And you have no question but have been successful before jury?
My review of the case, I came to the conclusion we had proof beyond a reasonable doubt. We were ready, willing, and able to go to trial in the case. Of course, as I said in my opening statement, prosecutors can't control outcomes, but I felt confident in pursuing the case to trial.
Did Merrick Garland ever pressure you to bring an indictment or to do anything in your investigation?
No.
Did anybody else in the administration, President Biden, Vice President Harris, et cetera?
I was given the independence to conduct my investigation, and I came to the decision to bring charges in this case without undue influence from anybody in the department.
And you dropped the case. Why did you drop the case?
The cases against Donald Trump were dismissed pursuant to department policy.
The Department of Policy, the Office of Legal Counsel said if somebody's president, you can't bring a charge against them or they can't be held liable. Is that correct?
That's correct. There had not been a case of this nature ever where someone was elected president with charges pending, and so that was slightly different. So we consulted with with the Office of Legal Counsel, and they determined pursuant to policy that the cases needed to be dismissed.
And you weren't pleased with that, but you had to follow the law, and that's what you did.
We followed policy throughout my investigation. My job was not to set policy, my job was to follow it, and that's what we did.
I want to thank you for your service. I think you're a great American, and you came out of this as being somebody who people can respect and look up to in a fashion that we should be instilling people's desire to go into justice, to go into law, and go into government. And you're an example of the type of person they should follow. I yield back the balance of my time.
Gentleman yields back.
What we just witnessed in this hearing was not a fleeting exchange or a procedural footnote. It was a moment where the machinery of government exposed its own internal tension, its own limits, and its own sense of duty. When Special Counsel Jack Smith explained why his office sought phone toll records under judicial approval, he wasn't describing a political strategy. He was describing fear, not personal fear, but institutional fear. Fear that the integrity of an investigation itself could be undermined if witnesses were pressured, intimidated, or silenced. Smith spoke carefully, deliberately, and with the weight of responsibility behind every sentence. He clarified that the subpoenas were not fishing expeditions, not content seizures, not surveillance of conversations. They were narrowly focused records showing who contacted whom and for how long, nothing more. And yet, even that limited step, he argued, was necessary. Necessary because of what he said he observed during the investigation. Public figures naming individuals, drawing attention to them, and setting off waves of consequences that altered lives overnight. This was not abstract theory. This was lived reality. Smith described how certain individuals involved in the election process found themselves thrust into the national spotlight, not by choice, but by rhetoric. Their names repeated, their credibility questioned publicly, their personal safety disrupted. In his words, their lives were turned upside down. For a prosecutor tasked with upholding the law, that is not a side issue. That is a core obligation. Protect the process, protect the evidence, protect the people. And then came the line that defined the moment. Smith referenced public statements that, in his assessment, crossed a line. Statements suggesting retaliation against those involved in the investigation, statements framed as warnings, statements that sent a clear message. Challenge power, and power will respond. In Smith's view, there was no ambiguity about what that meant for witnesses. It confirmed the very risk he feared from the beginning. This is where the hearing stopped being about one case and started being about the system itself. Because the question isn't whether one agrees with Jack Smith's conclusions. The question is whether the rule of law can function when legal accountability collides with political power at the highest level. Smith made clear that his team believed they had evidence meeting the highest legal standard, proof beyond a reasonable doubt. He stated plainly that they were prepared to take the case to trial. Ready, willing, able. But readiness is not the same as authority. When asked whether anyone in the administration pressured him, the Attorney General, the President, the Vice President, Smith's answer was unequivocal. No. He emphasized his independence. His decisions, he said, were his own. That statement matters because it removes one convenient narrative from the table. This was not a case driven by direct political orders. It was driven by prosecutors following evidence where it led, and yet the case was still dismissed, not because the evidence collapsed, not because the theory failed, but because of long-standing Department of Justice policy. A policy stating that a sitting president cannot be prosecuted. A policy never tested in circumstances like these, where charges were already pending before an election, changed the legal landscape overnight. Smith did not hide his frustration. He did not dramatize it either. He stated the reality plainly. His role was not to write policy. His role was to follow it. And so, despite confidence in the case, despite readiness for trial, the prosecution stopped. This is the uncomfortable truth Americans must sit with. The justice system can build a case. It can gather evidence. It can meet its burden. and still be forced to step aside when power intersects with policy. That doesn't automatically mean corruption, but it does mean limitation. It means that the law, as currently structured, has boundaries that appear precisely when accountability matters most. The congressman closed by praising Smith's service, calling him an example for those who want to pursue careers in justice and public service. That praise, delivered in a room often defined by confrontation, underscored the gravity of what had just unfolded. This wasn't theater. It was a professional reckoning. Because this hearing wasn't really about phone records. It wasn't even just about Donald Trump. It was about whether equal justice can survive proximity to power, about whether institutions designed to protect democracy are strong enough to withstand political gravity, about whether rules meant to preserve stability end up shielding authority from scrutiny. Democracy does not fail all at once. It strains. It bends. It reveals stress fractures in moments like this, moments where prosecutors say, "We were ready," and the system replies, "You cannot proceed." That tension is not partisan. It is structural, and it demands attention from anyone who believes the law should apply consistently, regardless of title or office. This is why hearings like this matter. Not because they settle debates, but because they expose them. They show us where the lines are drawn. And they force us to decide whether those lines still serve the public interest. If you believe transparency matters, if you believe accountability should not depend on position, if you believe the American system is strong enough to confront its own limits, then stay informed. Subscribe to Liberty Report USA. Support our work to expose the truth.